court or here to attention, you shall be heard. God save the United States, the great state of Florida, and the honorable court.
Be seated. Good morning and welcome to the First District Court of Appeal. We have 4 cases for oral argument this morning. We're going to take a break after the first case, and we'll have coffee in the Attorney Commons, and we, of course, invite you to join us there for coffee after the first case. So we'll call up the first case, which is a consolidated case of Merriam and Duran versus Department of Highway Safety.
Good morning. May it please the Court, Susan Cohen on behalf of Mr. Duran and Mr. Merriam, and I would like to reserve 5 minutes.
All right. Now, you understand that when you get the yellow light, that means you're into the rebuttal.
Yes, sir.
It's not a warning. That means you're into the 5 minutes.
Yes, sir.
Okay. And I'll try to remind you, too.
Just a couple of housekeeping matters before I start my argument. I had submitted last week and yesterday some supplemental authority, which actually isn't supplemental authority. It's basically advising the court of 2 additional cases related to this issue and the status of those cases. One was the case that was pending in the 5th District Court of Appeal. They denied the petition without an opinion, so that is no longer pending. There's a second case pending before this court. I just forwarded the circuit court opinion to this panel yesterday. That's pending under 1DO-104780 and is still, I believe, still in the briefing stage, just to bring that to the court's attention. Section 3161932 of Florida statutes is the Florida implied consent law. Under that law, it provides the circumstances under which a driver in the state can be asked to submit to a breath test. Under that section, it also advises that the Florida Department of Law Enforcement is to promulgate rules to ensure the reliability and the safety of the breath machines. And under those rules, the Florida Department of Law Enforcement has set out rules that require inspections of these machines monthly by an inspector at the local agency and yearly by somebody from the Department of Law Enforcement. Along with this statute is Section 3222615, which is a statute that sets out the formal review hearing, which is what is the issue before the court today. Under that statute, if you have a .08 or above, your license is suspended for 6 months, and it sets out the parameters of the hearings. Before a hearing officer, you can either have an informal hearing or formal review, and again, it's the formal review that's at issue in this case. Under that statute, the legislature, apparently recognizing that these hearings are different than most other administrative proceedings, also set out that these hearings are not under Chapter 120, but that the Department of Highway Safety and Motor Vehicles can promulgate rules for the proceedings in these hearings. The scope of review is set out. There's 2 things. If there's a breath test, and it's a little bit different for refusal, but that's not really the issue in this case specifically. So in addressing breath tests, that there was probable cause that the person was driving under the influence, but secondly, that their breath test was a .08 or above, which brings in the breath machine, which is what that result is based on when it's a breath case. The statute states that the party requesting the presence of a witness is responsible for payment, and the statute sets out the proceedings to enforce a subpoena if a witness fails to appear, a way to seek enforcement in the circuit court. Now, just because you can seek enforcement in the circuit court of a subpoena does not give a driver the authority to go to the circuit court and get a subpoena that the hearing officer denies, or as in this case where the hearing officer unilaterally says, you know, if you want to just phone it in, that's okay, just let us know. So the circuit court can't address the issuance of that subpoena or mandate that the person appear in person under those circumstances. It's only the hearing officer that can do so. The department has also set out rules that describe the forms for the subpoenas. The form subpoena talks about telling people where and when to appear. It, again, provides for the attendance of witnesses. It talks about the hearing officer can amend or strike if the subpoena subpoena ducis tecum does not comply with the rules. And although it does give the hearing officer the authority to quash a subpoena, nowhere in either the rules or the statute does it say that a hearing officer can unilaterally authorize somebody to appear by telephone. And that's what happened in these 2 cases. In these two cases, and in Edenfield and some other cases that will eventually be before this court probably, the hearing officer and actually the supervisor stamped the subpoena from the outset saying, if you want to appear by phone, just call us and we'll tell you what to do. So this is not a situation where a witness is across country. This is not a situation where a witness is afraid to come, as in some of the cases cited by the circuit court. This is not a situation where a witness has any problem in getting there. In fact, the testimony when he was called on the phone was, I'm across town. You know, they said I could
appear. Is there any rule or statute that prohibits an appearance by telephone?
Not in the specifically related to driver's license hearings. There is the general judicial rule of administration which requires, and we recognize that it is directed to county and circuit courts. However, we point out that there's the circuit court opinions that we have cited to this court from about 10 years ago when we went through this about 10 years ago, all cited to that judicial rule in finding that because these hearings, they're the judicial model, quasi-judicial model, and that a hearing officer is supposed to be as fair and impartial as a circuit or county court judge, that it was applicable, that there's nothing in these rules that says that you can do it. In fact, all the language, as I pointed out, addresses appearance, presence, making people come.
Does that rule prohibit telephone appearances, or does it merely establish the procedure to be followed in the case of a telephone appearance?
The judicial rule?
Yeah.
Yes, sir. It specifically says, the first part says what the court can do.
Yes to which part of my question? Yes,
it does prohibit a witness.
Okay.
If you go further down, although the department argued that it provides for that, if you go to, and I believe it's subsection C of that particular rule, in talking about testimony, then it says that that you cannot allow somebody to testify by telephone over the objection. In just a moment, I can give you the exact wording. Testimony. A county or circuit judge may, if all parties consent, allow testimony to be taken through communication equipment. So again, it's if all parties consent. In this case, the driver sent a letter at the very beginning recognizing what was starting to happen and said, we object to telephonic testimony. We object to that. This is not a situation where this is, as the department called it, the driver's expert witness. This is a witness relied on by the department. This is a witness that this court last year found that when we were being outright denied subpoenas for this witness, that not only the statute but basic principles of due process required this type of subpoena.
But it wasn't a fact witness.
Well, it is. If one of the facts is whether or not he's a .08 or above, it is, because that relies on the reference.
No, the question of fact would be whether the machine was tested properly, not whether he had that. I mean, the report itself shows the existence of the blood alcohol level.
It does, and the arrest and booking report is going to say I lawfully arrested. However, that's a totally separate issue from the rights of the driver to present evidence, to cross-examine evidence.
But you can't cross-examine the machine. I presume the only thing you could cross-examine the person who maintains it on is whether it was maintained properly.
Whether it was maintained properly. This is a person that does the inspections and does the maintenance. So if there are any issues, this hearing is very different. You don't have just.
Why is that so significant? It seems to me that the report itself might even be introduced as an exception to the hearsay rule.
That's not the issue. The issue is not what the department can do.
I know, but I'm trying to focus on this is not like a case where, let's say you had an assault and battery case where somebody says that he or she was assaulted and someone else says that no, he was the aggressor. And you had to decide this one-on-one he said case, let's say. Now you have a really important role in trying to figure out who is telling the truth. But here, how in the world does that apply here when all you're talking about is whether somebody performed testing procedures on a machine? I don't really understand how that applies.
Because it is the machine, and you cannot cross-examine the machine. The only way you can cross-examine the machine is by the people who are involved in preparing it. This is not a criminal case. There's no Brady obligation. There are situations where they may have in the record a document showing compliance and inspection.
Did you question the witness about all these issues?
He was not questioned in this case, and in one of these cases, both of these cases.
So did did you preserve it? Because, you know, you could have, I understand that there might be a credibility determination, but you, even over the telephone, the questions were never asked.
Yes, sir. But there's also, if in these cases, it shows it more graphically. One of the witnesses who appeared was Mr. Mayak. He is a district guy who travels all over the place. He did appear in person. Officer Thomason was down the street at the sheriff's office, like the breath test operator and the other people. He brought additional documents related to Mr. Thomason's machine. When questioned about the documents, he says, you're going to have to ask Mr. Thomason. Well, Mr. Thomason wasn't there to look at them. We don't know what's going to come out at the hearings because of the nature of the hearings. Sometimes there may be a document that says it passed, but what we don't know is it failed 4 times before it passed.
Well, how do we know how you were harmed by this if you didn't try to ask the questions? In other words, if you tried to ask questions and you were unable to get information maybe that you think you would have gotten had the witness appeared in person, then you could make an argument exactly how you were harmed. But how were you harmed if you didn't even try to ask the questions on the phone?
Because it's a greater issue than just Officer Thomason. As pointed out in the Enfield opinion by Judge Daniel, the hearing officer unilaterally decided which witness was important and which witness wasn't. Unilaterally decided, you don't need this witness to come. In this particular case, it was the maintenance, the inspection witness. But that in and of itself is the violation because we were not even given the opportunity to have him come in person. We don't know ahead of time. He couldn't look at the documents. As it turned out, there were documents, and in one of the records it shows there were questions about why was this a volume not met? Why were ask Officer Thomason. Ask Officer Thomason.
What would you have asked him had he come in person?
I'm sorry?
What would you have asked him had he come in person?
Those are some of the questions you would ask look at this document. We have had situations where all of a sudden they're talking about stuff and we're looking at our document and their document's different. And I would like to go ahead.
How far in advance were the petitioners in these cases notified that this particular witness was going to be appearing by phone? How far in advance?
When we saw it stamped on the subpoena, we knew that they were going to give them the opportunity, and we sent our letters immediately saying we object.
Okay, so
we don't know till they actually get there because there were other witnesses that were stamped that came anyway.
So was there an opportunity to get these additional documents to Mr. Thomason or whatever his name is to have reviewed ahead of time?
We didn't have them until the hearing. These all happened very quickly. The hearings are set within 30 days of our requesting it because otherwise licenses are suspended and the driver has to go without their license without their post-suspension hearing they're entitled to. So this all happens, you're talking a week, 2 weeks maybe time between getting everything, getting the subpoenas, getting people served, and getting to hearings. So it all happens in a very short period of time. So you just don't have the opportunity to do that.
You're at about 4 minutes. You can use you can use the time however you want. But
I'll reserve it.
Okay.
Good morning. May it please the Court, Douglas Sunshine for the Applee Department of Highway Safety and Motor Vehicles. The standard of review applicable in this case is whether the Circuit Court violated not a principle of law, not an established principle of law, but a clearly established principle of law, which resulted in a miscarriage of justice. This case is here on second-tier review, which is limited to whether the Circuit Court afforded procedural due process and whether it applied the correct law. Meaning, did the lower court depart from the essential requirements of law? As this court held in Tedder v. Florida Parole Commission, a ruling constitutes a departure from the essential requirements of law when it amounts to a violation of a clearly established principle of law, resulting in a miscarriage of justice. The petitioner has failed to cite any legal authority specifically prohibiting a witness from appearing by telephone, even over objection. As such, petitioner is unable to establish a violation of a clearly established principle of law. Even assuming that they did, they have failed to establish that there's been a miscarriage of justice in this case. The agency hearing officer reviewed the record, heard argument from counsel, and overruled the objection to the hearing officer's decision to permit Mr. Thomason to appear via telephone. Petitioner appealed this decision to the Circuit Court, which, sitting in its appellate capacity, also reviewed the record, heard argument of counsel, and determined that, quote, the receipt of sworn testimony via telephone did not deny petitioner's right to be heard in a meaningful way and was a pragmatic solution to a potential problem for witnesses who must attend to their duties at work and testify at administrative hearings and court hearings or trials too. In reaching this conclusion, the court is aware that certain cases may require the personal appearance of a witness. In such cases, the hearing officer is within the scope of his or her authority to continue a hearing to require a witness to appear personally. However, nothing in this record required the exercise of that authority. And a review of the record in this case evidences that there was no request for a continuance, that there was no substantial questioning of this witness to determine, as counsel indicated, they asked Mr. Malhiot all of these questions about the propriety of the machine and the test. They could have asked these questions of Mr. Thomason, but failed to do so at their peril. They didn't make any inquiry. They didn't ask if he had any of these documents. They made no attempt to provide these documents to him. They did not ask for a continuance, and that's essentially a waiver.
Could they have taken the witness's deposition, or is that a procedure that's available or not?
I would agree. There really is no time for that, and I don't believe that that's permissible. There really is no discovery permissible in these proceedings. But again, this wasn't a fact witness, as you pointed out, Judge Padovano. He simply provided testimony that would establish the documents that can come in already pursuant to 322.2615 sub 11. There's no requirement that any witness appear in these proceedings. The hearing officer is permitted to accept all of these documents submitted by the police officer.
If they wanted to investigate the possibility that the machine had not been maintained properly, how would they do that?
Well, certainly in that type of a situation, if it was determined and they showed a basis to have this inspector present,
how would they even investigate that?
It would have to be either through the testimony that's elicited from the person via telephone, and then they would make their objection to say, Your Honor, I believe that this person needs to be present. The judge then, using their discretion, makes a determination. I agree. I want to see their disposition, or for whatever reason. At that point, I would continue the hearing and either require the attendance or permit you to go into circuit court to compel personal appearance. But again, that's something that should be left to the discretion of the hearing officer. Again, realize that there are two different inspectors. You have an agency inspector, which is someone who works for the sheriff's office, who inspects it monthly, and then you have Mr. Thomason, who works for FDLE, who inspects it once a year. So, in essence, you have Mr. Malhiot, who testified, who reviews this on every month as to the integrity of this machine. What Mr. Thomason could provide further of that, other than his inspection that may have been 12 months before this, again, they didn't elicit any information to that extent for the hearing officer to make a determination. They raised no objection. I'm sorry, not that they raised no objection, but they asked for no continuance, and at their peril, asked no questions and proceeded. They shouldn't be heard now to claim that there's been a violation of due process. As recognized by the circuit court, petitioner's counsel acknowledged that the request for the subpoena was, in essence, a fishing expedition to the extent counsel stated that Officer Thomason was subpoenaed without any knowledge of whether his testimony would be helpful or harmful, and this was routinely done in many cases. The circuit court, with deference being shown to petitioner's right to subpoena certain witnesses, recognized the potential consequences of establishing a hard and fast rule requiring personal appearance of all witnesses to the extent, quote, a routine practice which requires the personal appearance of record custodians and breath testing inspectors could pose an impossible burden on these witnesses whose jobs require they do more than attend hearings. The state has a strong interest in regulating a citizen's privilege to drive. Therefore, the state also has a strong interest in assuring that the time demands of an inspector or custodian who is required to testify at hearings do not prevent him or her from performing the very duties which prompts the needs for the testimony in the first place. So, in essence, if they're subject to being subpoenaed and have to appear personally throughout the state, I mean, there are tens of thousands of these cases, and there are only a handful of inspectors for FDLE, and that every time that they want to subpoena them to hopscotch the state, it's simply not a pragmatic solution.
Well, how far would that argument go? I mean, will be at some point facing lawyers who routinely say, look, we're busy, we're just going to phone it in because we're busy, you know.
Well, Judge, I think
we don't need to go to court. We'll just phone it in.
Well, and again, this is an administrative procedure. It's by its nature less formal than a judicial proceeding. Attorneys routinely appear before DOA via video. It's simply a pragmatic solution with the technology is there, and they have not shown any true prejudice. Again, they're saying that by not being able to eyeball the witness and judge the demeanor, that somehow they're being denied due process. But again, and this is an extreme situation or example, you could have a jurist or hearing officer who is blind, who has the inability to see the witness, and that then would open the argument that that judge cannot provide my client due process because he can't see the witness speaking. Again, I would submit that they failed to establish a violation of a clearly established principle of law, and they've failed to show that there's been a miscarriage of justice in this case.
Counsel, why shouldn't the department have a rule that puts parties on notice that witnesses are going to be able to appear by telephone?
Again, this was...
DOA has one, doesn't it, that speaks to
Yes, it does,
appearance?
and that may very well be the next step that the agency takes is to initiate rulemaking in reference to this issue. But again, they did have notice to the extent that they request the subpoena. The subpoena is then mailed by the hearing officer to counsel with that information stamped on it. So, and as counsel indicated, they were aware at the time they received it that this witness may appear by telephone. So they do have notice to the extent that, however many days they receive it prior to the hearing, that this witness is subject to appearing by telephone. But I would agree that the agency, it may be provident of them to initiate rulemaking in this matter, and that will be my recommendation. Thank you.
Thank you.
Just to clear up one thing about the witness in this case, I believe Mr. Sunshine had it backwards. The witness who did appear was the area-wide annual inspector. He did appear in person and brought all these documents. The person who did not appear was the gentleman from the Jacksonville Sheriff's Office, who was only responsible for the machines from the Jacksonville Sheriff's Office. So he only appears at those hearings in Duval County on people who are arrested and give a breath sample at the Jacksonville Sheriff's Office and for those ones that he is actually subpoenaed for. So it's backwards. The one who did not come is the one who only handles the machines at the Jacksonville Sheriff's Office.
How was the subpoena ducis tecum? Was it subpoena ducis tecum?
Yes, sir.
And how was that handled? Did you have the documents on your end of this?
Well, that was another issue. Was what happens is because it's a very short time, there's no discovery, there's no time for anything. It's basically, this is our only opportunity to question it, and the only thing we can do is bring everybody there so we can question them about it. And so what he did was he faxed those documents before we even had a chance to look at them and decide if we wanted them placed in the record or what we wanted to do with them. The hearing officer had already labeled them and had them placed into the record. So we didn't even get the opportunity. They weren't provided to us ahead of time, which is okay because normally they bring them to the hearing, but they're right there and we can question them about it. So they were forwarded and just sent and placed into the record before we even had a chance to look at them and decide, do we want these documents placed in the record?
You didn't offer them in evidence?
We did not. They
so
just
you
got,
really what you
the
wanted
hearing
them
officer
for
did
was
it.
just a basis to question the witness about the examination.
And that's true, because sometimes there are things in those documents and sometimes they're not. But again, this is the only mechanism we have. This is not like other agencies where you have discovery, where you have opportunities to do all these things. This is a very short, quick process. The interesting thing was, and the department used this language in their response, and again today, it's whether the hearing officer wants to see the demeanor, whether the hearing officer feels it's necessary to see the demeanor of this witness. It's not whether the hearing officer thinks they're important or not. It's the witness of the driver thinks they're important and wants them there. That in and of itself indicates a lack of fair and impartial thinking on the part of the hearing officer. If the department is arguing, well, they didn't feel it was necessary for them to see this person or that they were that important. Well, the breath test is the basis of the suspension. So clearly, if this is not just the custodian of the record, this is a person who actually maintains the machine, his testimony is relevant, his testimony is important.
So what you're asking us to do today is to announce a rule of law that says in these type of administrative proceedings, due process requires that all witnesses appear live at the hearing.
What we're asking is that because of the wording in the statute as it exists, that all talks, and the rules, the administrative rules that all talk about appearance, that all talk about presence, that all say everything talks about the person appearing, there is nothing that authorizes this, that a hearing officer cannot unilaterally say, this person's important, I think they should come, this person's not important, I don't think they should come. This is not a situation where a witness asked originally to be excused because they had a conflict or they had a problem. This was just the hearing officer say, you know what, these people don't have to come anymore. And just to give you some history, in the past, they came all the time there was no problem. About 10 years ago, there were some other Tallahassee witnesses out of the 7th and 9th district circuits, I think it was, where the department started letting them appear by phone, and the circuit courts there said no. And those were witnesses that weren't even nearby, but it had to do with the breath machine. And even though they were taken to the Fifth DCA, the Fifth never issued an opinion on it. It was all just denied. So we don't know what they would have ultimately determined. Then the statute was changed, and they quit issuing subpoenas for these people altogether. Then came the lead decision out of this court, and they started issuing the subpoenas, and then they started putting this little stamp on there. So this is not like we all of a sudden say we have the right to these witnesses. This is the way it has always been. It's always been interpreted that way. They have always appeared. Officer Thompson has always come. I mean, he testified at the hearings. There's no reason I can't come. I used to always come. They just said I don't have to anymore. And that's what the problem is that there are no parameters for when people can appear by phone, that this was a situation where a hearing officer just picking and choosing who is important, who's not important, and we have no way around it because we cannot, notwithstanding the department's argument, go to the circuit court and ask the circuit court to enforce a subpoena if the hearing officer has excused the witness from coming. The circuit court has no authority. It's just by a petition for writ of certiorari, which is how we ended up here. Thank you.
We will be in recess now, and as I said earlier, we invite you to join us in the Commons for